slightly ways. Each state has reacted slightly differently. Some features of this crisis will be common to future crises that we want to anticipate, some will not. UNCITRAL's work addresses all those issues and encapsulates the common features of our experiences in a manner that speaks to all of us and which will help to tackle those future crises. And I would just like to quote to you paragraph 3 of the draft toolkit, because I think it does encapsulate the challenges that we are facing perfectly, or that we faced rather. And I quote, "The combination of these dimensions resulted in severe and long-lasting consequences on societies and economies. Social distancing of persons led to a tremendous shift in how work and business is being carried out due to lockdown measures, preventing businesses from operating out of their physical workspaces. States, institutions, and businesses scrambled to ensure that operations could be done as remotely as possible. In industries where remote work was impossible, businesses suffered a catastrophic loss of earnings overnight, and some were pushed to the brink of insolvency. As states closed their borders, supply chains were significantly disrupted, and an increased difficulty in trade processes arose overnight. This gross uncertainty and sudden disruption in business operations arising from the COVID-19 pandemic culminated in the suspension or breach of contracts on an unprecedented scale." And again, I think you have there encapsulated in a few sentences exactly what it is we're dealing with. And that may sound like an easy exercise to put this down in words, but I can assure you it isn't. And I would like to commend the Secretariat for doing the work of encapsulating things in such a pithy way, which then allows us to move forward. Another very useful part of the draft toolkit is part 2, which contains a very useful summary of the empirical measures which states have had to take to address these problems, often at very short notice. And importantly, those have been categorized in a way which identifies the commonalities between those ad hoc measures. And a simple look at the list thus immediately sets the parameters for the anticipatory action that, Yegishe, you were just mentioning, states may choose to take to shield themselves from the more serious effects of future crises. I won't waste the time now to go through that, but I do invite you to do that because it really is quite enlightening. My last point on the draft toolkit is this. I think an important aspect of the draft is its recognition and conclusion that to a large extent, the legal instruments that we need to assist address future crises already exist, and that what is required is to raise more awareness of the same and of their benefit to prepare for future crises, rather than the development of completely new instruments. And you will find that at paragraph 17 of the Secretariat's most recent note, ACN 9-1144, which notes that generally it was highlighted that awareness raising and educational activities like the UNCITRAL days were needed so that MSME entrepreneurs could utilize the existing UNCITRAL instruments better, and paragraph 21 makes a similar point. I think this is an important recognition at a time when there's a general feeling of regulatory overkill, and that there are already too many legal instruments in circulation. As explained by the Secretariat, the tools already exist, and it's more a question of raising awareness of those tools and of their benefits in the specific situation of averting future crisis. Now, with this, I turn to the specific topic of this keynote address, dispute resolution, and to the first aspect thereof, that is, how can existing legal instruments facilitate dispute resolution in times of crisis? Now, the draft toolkit, unsurprisingly, identifies two main areas of work: arbitration and mediation. I will focus on arbitration because it does remain the central pillar of any alternative dispute resolution toolkit. And this is not to detract from UNCITRAL's important work in the field of mediation, including the Singapore Convention. It is undeniable that the global pandemic created vast disruption in the field of dispute resolution. This was addressed with varying degrees of speed, but generally very quickly, by courts and tribunals resorting to remote filings and hearings. That has introduced changes in the field that are there to stay, and which will have collateral benefits, for example, in terms of climate action, as they avert the need to travel in a great number of cases. Now, if I may share my own experience, and of course, I understand that we will all have slightly varying experiences, but perhaps just to share mine in this field. What I have found during the pandemic and since is that remote hearings work extremely well in a great number of cases. I think in a lot of cases that we are talking about here, which are to address the needs of micro, small, and medium enterprises, ordinary, if I can put it that way, commercial disputes, there really is no issue at all with remote hearings, be it submissions or the hearing of witnesses. It works perfectly well. And also, of course, for deliberations in all cases. What I have found is a reluctance by both parties and counsel, and sometimes arbitrators, to use them for the merits hearings in very large arbitrations, even commercial, and certainly for large investment arbitrations. And this is because there, the subject matter, the complexity of the evidence makes it more of a challenge. I'm not saying it cannot work, but I think there are cases where physical hearings are still preferable, and we're not going to see, obviously, the disappearance of those. One debate which has arisen and which is addressed in the draft toolkit at paragraph 70-71 is whether there exists a right to a physical hearing. And that has been addressed by ICA, that has done a survey and published its results in March 2022. So if you want to read that, you can see paragraph 71 of the draft toolkit. It seems to me that this is simply an example of the saying, I'm sorry, I'm going to say it in French, la nature a horreur du vide, nature hates a vacuum. And when there was nothing really to discuss and everyone was just happy going ahead with remote hearings, obviously something had to be discussed by lawyers, otherwise they get bored. But the reality is that there isn't much doubt on this. And I think that the fact there was a debate is more to do with what has been termed sometimes as due process paranoia, where arbitrators become incredibly careful about accommodating every party's wish for everything, rather than actually do what is efficient and necessary for the case. So I think that was one manifestation of it, but I think it's a debate that is largely now closed. And the right actually to a remote hearing cannot really be debated. There may certainly be parochial examples where it will be a problem, but by and large it isn't. Now, an interesting point noted in the draft toolkit is the extent to which our current instruments, that's the New York Convention and the UNCITRAL model law on international commercial arbitration, may still fall short on one small but rather important point when you are in that sort of situation where people really cannot meet. And that is the electronic signature of awards. And that's addressed at paragraph 74 of the toolkit. UNCITRAL has done what it could in that area through, some of you may recall, the recommendations that were published regarding the New York Convention, Article 2, in the in 2006, and at the same time, the amended model law. But the problem will remain, I'm afraid, until, if that ever happens, the New York Convention is amended. The New York Convention uses wording of 1958. And you will have courts and tribunals that will have a dynamic reading of those requirements, but unfortunately you will have courts and tribunals that won't. So there isn't a silver bullet for that. And it's annoying to think that this does remain a real impediment in that specific situation. Now, in terms of preemptive action, the steps that states can take in this field are accordingly clear and well known. And that is adopt a modern arbitration law, and ratify the New York Convention, where they haven't done so yet. As some of you may know, my country, Mauritius, has quite an extent of experience now on this, having worked at all times with UNCITRAL, with the Permanent Court of Arbitration at The Hague. And that is experience that we're very, very happy to share. And any state that would like us to share that experience should please either reach out to me directly or through UNCITRAL, through Anna and Judith and others. What we have found is that, yes, the instruments are there. One can easily enough adopt the UNCITRAL model law, ratify the New York Convention. We've even gone a bit further and tried to make the model law even more arbitration friendly. That can be done by making the points of contact with the judiciary even less, or minimizing those points of contact. But the reality is that this will only work if you have a supportive judiciary. And that really is the main problem, as it were, to create conditions that are favorable to arbitration generally in the country and within the judiciary. And that's not to say anything against the judiciary. It's just that the traditional outlook to arbitration has evolved, and it has evolved in developed jurisdictions over the years. So just to take one example, if you look at India, that adopted the model law lock, stock, and barrel many years ago now, in 1996. I think it was rather ironic that last week you had events in London marketing India as a seat for arbitration. And at the same time, you've got the Supreme Court of India ruling that unstamped arbitration agreements cannot be enforced. So you can have the best law in the world. If the judiciary doesn't follow suit, it's not going to work. So much for arbitration as a facilitating factor in times of crisis. Let me now turn to my final point, which is arbitration as a disrupting factor in times of crisis. And I come now, of course, to the topic of investment arbitration. The Secretariat noted in paragraph 11 of its working paper 1119, published last year, and I quote, that considering that foreign investors were impacted by the state's restrictions, the Secretariat organized a webinar to explore the potential rise in investment arbitration claims brought against measures taken by states in mitigating the COVID-19 pandemic. In the absence of specific treaty-based provisions addressing the right by states to regulate in exceptional circumstances, two concepts under customary international law, namely the security exception and the necessity defense, were highlighted and discussed. Difficulties in the application of these concepts were identified, including the high threshold to be fulfilled and the diverging interpretation by tribunals. A pending investment claim related to COVID-19 measures was also touched upon and illustrated the relevance of the topic. While presentations and discussions focused on substantive provisions of investment agreements that are not currently within UNCITRAL's mandate on ISDS reform, 15 procedural tools, such as the issuance of joint non-binding interpretations or declarations by states on the impact of similar circumstances on regulatory activities and investment protection agreements, were further discussed. End of quote. Now, to my knowledge, and I've asked around me amongst practitioners in London, Paris, and Singapore, so to my knowledge, such claims have not in fact materialized, and I would be interested to hear from others who will already have seen such claims. Although one must, of course, wait and see, there being no time bar in the vast majority of investment treaties. The fact that there haven't been claims as such does not really mean there isn't a problem for states, because the very fear of potential investment claims is one factor that has been cited when people refer to this question of regulatory chill or regulatory freeze. And it must be right that a number of states, when they were taking COVID-related measures, would have thought quite carefully about the compatibility of the same with their investment treaties. Now, this, of course, takes one straight to the current work of UNCITRAL on the reform of ISDS, as noted by the Secretariat. That is a complicated topic, and I would only make the following comments in that respect. As you will have heard from the quote I gave you from Working Paper 1119, there is a call in that specific area for substantive reform of substantive protections under treaties rather than simply procedural reform. And that is also a call that has arisen in other respects within the group, the work of Working Group 3. That presents some difficulties, and let me just explain that very briefly. The first difficulty is a legal one, and that is the work of UNCITRAL on wider reform of ISDS arose from the work that I chaired on transparency. And the work on transparency made full use of Article 30 of the Vienna Convention on the Law of Treaties to allow a multilateral treaty to amend without amendment, if you understand what I mean, simply because it is a later treaty in time, the earlier BIT. Now, that was fine, and there was analysis of that in the context of transparency. It's clearly fine when you are talking about procedure, but there must come a point where it could be considered as a disguised amendment, and that point may well be reached when you're amending the substantive provisions. So that's a legal impediment. Also, the work on procedure is already very difficult. And I think if one tried to find consensus on substance, that probably would be too ambitious. So much for reform on substance. On what can still be done, well, as you probably know, two approaches have been advocated by different camps. The two are not mutually exclusive. The EU and a number of states would like a systemic reform, and that is the introduction of a multilateral investment court. Other states prefer an incremental or soft law approach. The advantages of the systemic approach, it is said, is that to a systemic problem, there must be a systemic solution. And if I can explain that as briefly as possible, the explanation is this. Investment arbitration has evolved using a tool coming from another field, which is that of commercial arbitration. Because of that, you've had this mechanism of ad hoc tribunals. In the field of commercial arbitration, the tribunal is only accountable to the parties whose dispute it is hearing. It's not accountable to a wider system. It is hearing that dispute and no other dispute. Now, the problem is, it is said, is that in the field of investment arbitration, because all these provisions are very similar, FET, FPS, expropriation in all the treaties, and because of the publication of these awards, there is now a body of case law which cannot be uniformized if the tribunals are not going to see some form of systemic duty. And so this is why the EU and others are advocating for a systemic solution, saying, well, what we need now is one forum in which all these claims can be heard. Another argument possibly in favor of a court is that a court system may allow for a different emphasis, because again, because of the importation of the commercial arbitration model and of the personnel from commercial arbitration, so a lot of commercial arbitrators, there is a feeling that perhaps the field has evolved as if this were like contract law, as if this was a commercial dispute, whereas the better analogy would be with public law. And by having a new forum looking at these issues afresh, you could well have a different view taken, which in a way would also perhaps resolve the issues of substance that are being discussed, because public law, of course, is well accustomed in keeping that balance between the interests of the private parties that are bringing the claims and wider regulatory needs. And just a last word on the incremental approach. As you will have heard, the toolkit does refer to that, and there are proposals that are made which could help, such as the amendment of existing treaties and wording to be used in new treaties. This will not alleviate the problem with regard to investments made prior to ending existing treaties. This is what I wanted to share with you as an introduction to this workshop. And the toolkit promises to be a very important and useful instrument, and I wish you a productive day of debate on the same. I thank you for your attention.
you for a very interesting and very comprehensive keynote address. You have touched very important aspects that are being highlighted due to the pandemic restrictions, and which re-emphasizes the importance of the remote, for example, hearings, and also somehow touching the problematic potential of arising of potential investment claims due to the regulations and restrictions that have been imposed by states during the pandemic, and also the ways out which the country should think in that direction. Of course, important thing is to modernize the arbitration laws, which I think is one of the key aspects. Also having a friendly judiciary for the arbitration, that's a key part, because we have been facing similar challenges in different countries where the arbitration laws are not, or the courts are not so arbitration friendly, and which creates some impediments for that. But just from our experience, Armenia has been quite active in that regard. We have been reforming our arbitration, commercial arbitration law in line with the UNCITRAL model law, and the most recent version of it. And we also have been active in that regard, because now at this point, Armenia is in the process. It has established an arbitration center already, and we're trying. The Ministry of Justice is very extensively working in making the dispute resolution in arbitration format more widespread as an alternative dispute resolution tool. So I think without more ado, because we are actually running a little bit late in time, because we started a bit late now, I would like to transfer to the next topic, which is the disruption to international trade and contractual arrangements on enterprises. And I would like to transfer the floor and to Ms. Anjubin and for presentation on the topic. Thank you very much.
Thank you very much for giving me the floor, and thank you to Salim Mulan for setting the stage for these discussions. Very briefly, I will try to catch up if I can. I wanted to introduce the project and what brought us to preparing this toolkit that will be presented to the Commission this year. And in order to do that, I also wanted to give you a very brief introduction to UNCITRAL, because I'm not sure that all of them, those that are online and in the room, are familiar with our work, or if you're familiar with our work, that you know about our methods of work and about our structure. So very briefly, UNCITRAL is one of the two legislative bodies of the United Nations General Assembly. We are dealing with private international law issues and with international trade law more specifically. And the International Law Commission deals with public international law. The International Law Commission is not a member state, it's not an intergovernmental body. We are an intergovernmental body insofar as we adopt the work that we do in our commission, and that we have a number of member states, and that our work is led by states. So we have currently 70 member states. All UN members are, of course, invited and can participate in UNCITRAL's work. We don't make a distinction between members and non-members, except when it comes to voting, which happens extremely rarely. And we have a number of accredited observers that are either non-governmental organizations or intergovernmental organizations that contribute to the technical nature of UNCITRAL's work, because we produce legal texts, we produce international conventions that member states can then accede to. We produce model laws that some were already alluded to in the previous intervention, and that can be used by states to then enact their own law following the UNCITRAL model, which in itself is already the result of harmonization, modernization of international trade law. And we produce all sorts of other legislative tools, such as legislative guides, texts that are meant for parties to use, that can be included into contracts. So you have a whole range of legislative texts that are being produced by UNCITRAL. What is important is that these legal texts, in fact, are essentially addressed to businesses. So we have as end users states, of course, because they're the ones who are enacting, but the ultimate beneficiaries are private parties involved in international trade, in international transactions, and in various other areas of business law. So here on the slide, you have a number of the areas of our work. We have a special dedicated project on MSMEs, where we have produced already a legislative guide on the key principles of a business registry, with the view to encouraging MSMEs to leave the informal economy and to join the formal economy, which again, we will see in the toolkit. In times of crisis, it's very important to be on the radar screen of the government so that you can possibly benefit from some of the support or the tools that the government puts in place. If you're a part of the informal economy, of course, you don't exist. So that's what we will present to this year's commission a toolkit on, or a draft tool guide on access to credit for MSMEs. We have an entire framework on electronic commerce, and we will talk also here in the toolkit more about identity management, but we will also talk about public procurement tools that are very critical in times of crisis, like we have just gone through. We are looking, of course, also at contract performance. Here we have identified in the toolkit the CISG, which is one of our framework of, flagship conventions on the international sale of goods. And then we have a number of tools to resolve disputes. We've spoken already about arbitration, mediation, but there are also other tools, such, for example, a guide on online dispute resolution that became particularly critical during the pandemic. And last but not least, at the end of this business cycle, sometimes the company goes insolvent. And here we have a strong framework on insolvency, which again has been particularly topical when looking at the insolvency of small and medium enterprises during the pandemic. So how did we come to preparing a toolkit? It's been a journey. So we started with our own experience during the time of the pandemic, when we had to hold a session of our commission, but where we had to move everything online. And there we actually, during this 2020 session, we actually set up a series of webinars on the different virtual panels on the different areas of UNCITRAL's work and how they could provide a response to the pandemic. And this was then conceptualized by 3 states, the Russian Federation, Armenia, and special thanks for bringing it to UNCITRAL, and Vietnam. And as a result, we prepared exploratory work through a questionnaire that was sent to states about what is it that you're putting in place, what are the measures that you're taking, and what are the obstacles that the businesses in your jurisdictions encountered. And from that, then we prepared a first set of conclusions, and we also compiled and treated in the form of best practices, the responses that we received from states. You will find them summarized in the toolkit in their original form as they came. And then we got a mandate during the 2021 session, which asked us to start to look into these various responses that we got, try to find some commonalities, try to identify the major hurdles, and also to see the texts that were most often cited and used in overcoming the pandemic. And during that time, we also led a number of meetings. We were very grateful to benefit from an APEC meeting organized by the government of Vietnam. And I'm thankful to Dong, who's online, for organizing it for and with us, which allowed us to have a discussion about the toolkit. And we are now hoping to bring to the Commission in this year's session the toolkit as you have before you. We have it as a final text because everything we present to the Commission is in 6 languages. So everything that you will see and discuss at the Commission is already being translated. So we're not expecting to bring any changes, but we expect that the government or the delegation of Armenia will give a summary of the findings and the discussions held during today's workshop, and that this will further inform the Commission on what can be done with this toolkit, how to use it, and we will present it in this afternoon session. So thank you very much for giving me the floor for this opening for the introduction of the toolkit. And now we're going to look into what you find in the toolkit are the findings of our questionnaires to states, the submissions that were made by states, the contributions that we got and that we put on a dedicated web page. And without further ado, because I'm now the moderator, I'm going to give the floor to Lev Gershanok. Lev is the director of the legal department in the Ministry of Economic Development in the Russian Federation. He heads the Russian delegation in UNCITRAL. And so it's a pleasure to see him here again. And I give you the floor, Lev, please.
Thank you very much. Good morning, everybody. And I will speak about experience of Russian Federation. In 2020, the whole world faced the consensus of the global health crisis. The restriction had a devastating impact of national economics and cross-border trade. The Russian government has undertaken a number of measures to overcome the negative burden that the pandemic has brought with it. The effectiveness of these measures is still highly appreciated after almost 3 years. In the context of our topic today and the development of a policy toolkit based on UNCITRAL documents, I would like to note that the measures taken by the government of the Russian Federation were generally comprehensive and covered all 4 areas considered in the toolkit present today: digitalization of trade, insolvency, support of SMEs, contractual obligation, as well as many other areas that were not the subject of the current project. At the event which took place this February under the auspices of the APEC Economic Council of the context of the UNCITRAL COVID project, we made an overview of the measures taken by the Russian government related to delegations of trade. We talked about personal medical assistance, artificial intelligence technologies, used to talk the negative impact of COVID-19, experimental legal regimes, the regime which allows approbation of new technologies in specific areas along which regulatory flexibility. Today, I would like to focus on two areas this way, particularly affected by the negative effects of pandemic and where effective measures were taken to prevent such effects in the area of bankruptcy and support for SMEs. In order to prevent a sharp increase in the number of insolvencies of economic entities and to ensure the stability of the economy during the spread of COVID infection in 2020, the Russian government introduced a moratorium on bankruptcy. The moratorium was in force since April 6, 2020, and was valid for 6 months in relations of strategic and core organizations and organizations from the most affected sectors of the Russian economy. For organizations from most affected industries, it was extended for another 3 months. The moratorium applied to more than 500,000 organizations, 14.2% of all legal entities, and 1.6 million individual entrepreneurs, 40.3% for all individual entrepreneurs. During the period of the moratorium, first, creditors couldn't file for bankruptcy of the debtors subject of such of moratorium. Second, the debtors' own obligation to file for bankruptcy was suspended. Third, the enforcement precedents related insolvency were suspended. Fourth, no foreclosure was allowed. Fifth, penalties and other financial sanctions were not charged. And finally, payment of dividends and the offset of counterclaims were not allowed. At the same time, the Supreme Court of the Russian Federation clarified that the anti-COVID moratorium on bankruptcy didn't relieve the ones and top management of companies from subsidiary liability for the debts if the controlling persons knew that signs of insolvency had arisen earlier, and this wasn't changed nor overcome this crisis. In order to ensure prompt response and the possibility on adapted to a potential change in the situation, a mechanism was created to exist the moratorium and remove the restriction associated with it for business entities that considered that they didn't need the protection provided for by the moratorium. In order to provide additional protection for the debtors, in June 2020, federal law on insolvency was amended to create a new tool to support debtors under a moratorium after it ends. Mechanism for digital installment for obligations in case when the debtors during the moratorium filed to the court a statement of his bankruptcy. Such an installment plan could be granted for a period of 1 to 3 years, depending on the condition and category of the debtors. The moratorium affected not only the persons to whom it applies, but also the counterparties. This means that during the moratorium, the counterparties of the sub-moratorium organization wouldn't receive the fulfillment of their claims. However, under the circumstances, a moratorium was necessary. No one knows what could have happened to Russian business and the economy as a whole if the government of the Russian Federation hadn't taken such anti-crisis measures in a critical situation like COVID-19. Uncertainty about the future would have pushed business to file for bankruptcy more. Then moratorium also allowed to relieve unnecessary tension. In terms of supporting SMEs during the pandemic, the government adopted a list of various measures, in particular with regard to SMEs operation in the most affected sectors of the economy. The package of measures for SMEs was aimed at reducing the administrative burden, minimization, not production costs, reducing and different tax and insurance payments, expanding special access to credit resources. For example, more than 2 million SMEs and individual enterprises received subsidies for wages, which made it impossible to provide employment for more than 3.7 million people. In conclusion, we would like to note that we hope that the experience undertaken by the Russian Federation in the framework of preventing the negative consequences of COVID-19 would be useful in the context of discussion of recommendation and entering in the policy toolkit based on UNCITRAL text. We also open the future discussion. Thank you. That's all.
Thank you very much, Mr. Gershanok, for this presentation and for the focus that you put from the outset on MSMEs and on insolvency matters and on the measures taken by the Russian Federation with a particular focus on the moratorium and what it meant for these companies during these difficult times. I'm giving the floor now to Nguyen An Duong, who is Director of the Department for General Economic Issues and International Studies in the Central Institute for Economic Management in Vietnam. And again, thank you very much, Duong, for being our host in the APEC forum in the Economic Committee in APEC, which allowed us to have a very good discussion of the toolkit. Over to you, please.
Thank you. Before I start, I'd like to thank the organizers and including my friend Marianella for the invitation. And I would love to build upon the policy dialogue we had earlier within the EC1 of this year to have a full day workshop in Seattle later this year. But unfortunately, given my workload at the office, I think that proposing that one would be overwhelming for my portfolio at this stage. But I have several brief points to talk about today, about the legal infrastructure for the digital economy in Vietnam that we have built upon during the COVID-19 pandemic. And in the past 3 years, first, Vietnam has been working extremely well in the areas of the digital economy, and we have built the action plan for the digital economy. And the first areas that we work on is to set out a roadmap for developing the digital economy, and we set out the target to achieve around 30% of the GDP by 2030 as the digital economy. So meaning that the digital economy will account for 30% of GDP by 2030. So which is very ambitious. And after that, we also have a different action plan to develop the digital government in Vietnam. And we, with the view that the digital transformation of the enterprise need to be complemented by the effort of the government to provide good public service by digital platform. And we develop the KPI for different government agencies. We require them to identify the tasks and including the regulations that need to be changes to facilitate the provision of online services. And one of the key areas for the public service then is the payment for the online payment for the public service. In the past, most of the public service were conducted online, but only until the submission of the documents. But when they make the payment, they often have to go to the banks, to make the payment. But during the COVID pandemic, even that the people could not come to the banks in person, then the regulations also changed to facilitate the online payments. So that complete the cycles for the online public services. And the third areas that we work on is that we conducted the assessment of the readiness for Vietnam in the both technically and legally for the Asia framework on cross-border paperless trade in the Asia and the Pacific. And this one has been promoted by the UNCITRAL, and Vietnam has been considering very actively about the possibility of whether we could join it. And more importantly, what we need to improve in terms of, to be part of the framework, and then what is the capacity that is needed, after we have after we join that one. At this stage, the consideration is still in progress, but nevertheless, the process was important in the sense that we had a comprehensive assessment of the key areas related to custom modernizations, the key legal infrastructures, including the law on electronic transactions, the law on cybersecurity, the law on cyber information security, those kind of things. Really, the identification also involve a consultative process that engage all the stakeholders, the government agencies, the business community, and the academia. And this kind of consultative process also have the stakeholders to understand the key legal infrastructures that we need to improve. And with those kind of activities, Vietnam certainly still had a lot of things to learn in the digital economy. But according to the European Center for Digital Competitiveness, Vietnam was ranked the first in the Asia and the Pacific region in 2021 in terms of the Digital Riser Index, which this index measures the changes in terms of the mindset and the policy effort toward the digital economy. So that was one of the key achievements that we have. And my final point was the online dispute resolution. Vietnam, before the COVID-19 pandemic, Vietnam only had some research on the online dispute resolution, but we took no actions in terms of the legal framework. In the Economic Committee of APEC, we also consider actively, but the domestic stakeholder did not consider whether we should opt in the ODR framework of APEC yet. But during the COVID-19 pandemic, the Prime Minister issued an action plan on e-commerce where he allowed for the pilot implementation of the online dispute resolution within Vietnam. And with that, the Vietnam International Arbitration Center, Hanoi International Arbitration Center, started to develop their own infrastructures for their own platforms for the ODR, and they started with the actual cases. They start to develop the model clause, the model guidelines for the implementation of the online dispute resolution. And some of the cases were implemented. And we also had a pilot project funded by the Australian government to help build the capacity for the MSME in order to utilize the ODR. And one of the parallel discussion was about the revision of the consumer protection law in Vietnam. And one of the key issues we discussed is whether the online platform can be used. And I think at this stage, the draft allow for the use of the online dispute resolution. But the second thing is the definition of the consumer. In the past, we used to refer to the definition of the consumer being both individuals and small and medium-sized enterprise. And when the government had some proposals to narrow down the scope of the definition consumer to cover the individuals only. But the National Assembly said that we should stick to the existing framework, keeping consumer to cover both individuals and the SMEs. And with that, the online platform for dispute resolution will help with the consumer, because they have a broader set of the demand for that. And I think that is also induced the applications of the ODR and the ongoing revisions of the ODR legal infrastructures. With that, I thank you for your attention.
Thank you very much, John, for sharing the experience of Vietnam, and also for showcasing, as you very aptly did, the silver lining of this very dark cloud that has engulfed the entire planet. Two remarkable issues that you mentioned, and two sort of highlights of this silver lining. One is the digitization of many services and government services for sure, but also supporting the digitization of other services in the area of international trade, and referring to the key legal infrastructure that is required to make sure that these transactions are legally recognized and that they can produce their full effect, even if they're taken online. And second, the discussion on the online dispute resolution. It is absolutely clear from our observation that the pandemic has resulted in a boost to online dispute resolution, but we also see that there are different models out there, and that I think one of the outcomes of this this research, and the research we're currently carrying out in our dispute resolution in the digital economy stock taking, is that we have to look very closely into online dispute resolution. It's interesting to see that the issue of who's a consumer on platforms, whether it's only the individuals or whether it's also MSMEs who are trading on these platforms, who are using these platforms to trade, but also who are using these platforms to only settle disputes. It's interesting to see this dichotomy and how you have overcome it. So thank you very much for this contribution. I'm now not giving the floor, but I'm asking to please put on the video that has been recorded by Karin Kaiser. She's a delegate in UNCITRAL's working groups 2, 3, and 5, and she will share the experience of the United States and some observations on the impact of the crisis. Over to Karin.
Sorry, just 1 minute. We have some technical problems.
Dear participants, I'm happy to send my recorded greetings to you all, and also my apologies for not being able to join you in person or in real time virtually for this panel due to pre-existing commitments. I'd also like to take this time to thank the Ministry of Foreign Affairs for Armenia and the Secretariat of UNCITRAL for organizing this event, as well as for their kind invitation to participate in this panel discussion on the impact of the international health crisis on the legal infrastructure for trade. As such, I'd like to share some observations regarding legislative responses to the COVID-19 pandemic that were taken by the United States. I hope these recorded remarks contribute to further discussions during the course of this event. The United States was one of the countries that responded to the UNCITRAL Secretariat's questionnaire regarding measures taken to provide relief to businesses from the negative impacts of the COVID-19 pandemic. Now that the state of emergency regarding the pandemic has been lifted in the United States, it may be useful to recap the measures the United States reported in response to the questionnaire, which summarized the various measures implemented through the Coronavirus Aid, Relief, and Economic Security Act, better known as the CARES Act. Now, not all measures were implemented through the CARES Act, but a good chunk of them were, and so I'll highlight those first. Specifically, the United States shared information that it took on insolvency, e-commerce, dispute resolution, business-to-business contractual relations, public procurement, transportation and logistics, corporate governance, and the criteria for receiving support and steps to monitor compliance under the CARES Act. In insolvency, for example, the debt limit for small businesses to take advantage of streamlined restructuring procedures was raised from $2.7 million to $7.5 million, allowing more small businesses access to restructuring. Originally enacted for only 1 year, the increase in the debt limits has been extended twice and will now continue into 2024. For small and medium enterprises, over $350 billion in funds and tax credits were made available for businesses with 500 or fewer employees to provide, among other measures, disaster assistance, coverage for payroll costs for 2.5 months, and the requirement of providing emergency paid sick leave and family leave for those affected by the coronavirus. The transportation sector also received substantial financial support, primarily through the aviation, passenger rail, and public transportation industries. There were safeguards designed to target the funds where needed most. For example, the CARES Act included important limitations, such as the prohibition on the use of any of its funds for certain levels of executive compensation and severance pay for corporate officers and other employees whose compensation exceeded specified amounts. Finally, the CARES Act created, sorry, my slideshow is getting ahead of me. Finally, the CARES Act created specific enforcement mechanisms, both through administrative investigations and referral by the Department of Justice for civil or criminal investigation. Now, turning to some of the measures that were not implemented through the CARES Act. For public procurement, the United States reported that existing procurement authorities were used to require companies such as General Motors and 3M to produce essential healthcare products such as ventilators and protective gear. For e-signatures, U.S. business was well positioned to adapt to using e-signatures, given that e-signatures have been generally available since 2000, when federal legislation governing the use of e-signatures between agreeing contracting parties was enacted. From the early days of the COVID-19 pandemic, many U.S. states signed executive orders or enacted other forms of law to allow remote online notarization, in some cases through the use of video conferencing to verify that e-signatures were being used. Regarding dispute settlement, courts and arbitral institutions in the United States moved quickly to the use of video conferencing to minimize or avoid the disruption of dispute settlement. One topic for which the United States did not have anything to report on the UNCITRAL questionnaire was in response to the question about obstacles identified by businesses to cross-border trade resulting from measures to respond to any obstacles to cross-border trade as a result of the pandemic. Nor did the United States report any specific legislation that it passed itself to respond to any obstacles to cross-border trade. Of course, the pandemic starkly revealed the fragility of global supply chains, and the U.S. responded with Presidential Executive Order 14017 being issued, which established a government-wide assessment of vulnerabilities of the U.S. critical supply chains and the identification of ways to strengthen the resilience of those supply chains. Such efforts to strengthen global supply chain resilience, in particular for healthcare, but also more broadly, will certainly remain an important objective, even as the emergency aspects of the pandemic recede. Turning to the draft toolkit, the United States looks forward to a discussion of that toolkit, which we are currently reviewing as we prepare for the Commission's upcoming 56th session. So at this point, we have only very preliminary observations, but at first blush, it seems that the thematic structure of the draft toolkit will make accessing and referring to the relevant UNCITRAL instruments easy for those who may be less acquainted with those documents. The draft toolkit also seems to highlight a number of new and existing UNCITRAL instruments dealing with e-commerce, insolvency, and dispute settlement, to name just a few, that can be useful for responding to global supply chain disruptions, whether caused by a future pandemic or other unanticipated events. And finally, the draft toolkit seems well placed to help with what one might call preparedness for countries that may not have had these measures in place before the pandemic, but want to be ready for the next shock whenever it arises. I hope these remarks contribute to the general discussions at the event today, and I wish you all a productive rest of the day. Thank you again to the Ministry of Foreign Affairs for Armenia and the UNCITRAL Secretariat for their efforts in organizing this event.
Many thanks to Karin Kaiser from the Department of State in the United States. And I'm giving the floor now to Mr. Fumiyasu Miyazaki, who's an attorney at the International Affairs Division in the Ministry of Justice of Japan. Fumiyasu, you have the floor, and thank you very much for staying up late to join us. Thank you.
Thank you for your kind introduction and giving me the floor. I'd like to thank the organizer as well. To be honest, it's not so late. It's still 5 p.m. I'd like to share some initiatives taken in the civil law field by the Ministry of Justice of Japan in response to the COVID-19 pandemic. The ministry introduced a legal amendment for the digitalization of receipts in commercial transactions, created a Q&A for lease agreements, and revised rules related to holding shareholder meetings. Recently, there has been an increase in e-commerce transactions conducted over the internet. When engaging in e-commerce along with the payment, the seller provides a receipt to the buyer. Under the previous civil law, buyers could only request paper-based receipts. However, there is a growing demand from buyers to receive receipts through easily manageable electronic means instead of physical paper receipts, especially when receipts are required for tax processing at work. Having to physically go to the company to receive and store paper-based receipts becomes inconvenient, particularly in light of the recommendation for remote work due to the COVID-19 pandemic. Similarly, for sellers, if they have to create paper receipts, it incurs costs such as printing and mailing expenses. Considering these factors, the civil law has been amended to allow payers to request the provision of electronic data recording the receipt contents instead of physical receipts. Regarding electronic receipts, similar to the traditional paper-based ones, they only need to include the recipient's information indicating the buyers and sellers along with the data and payment amount. Along with the date and payment amount, sorry. As for the method of providing electronic receipts, it is sufficient if buyers can receive or access them, even if they don't actually view them. For example, sellers can send receipt data to the buyer's smartphone app, PC app, or email address, providing easy access to buyers. Buyers can also input identification codes or other identifiers to access and view the receipt online. However, it is important to consider cases where small-scale businesses find it challenging to immediately adapt to issuing electronic receipts due to insufficient systems or unfamiliarity with electronic devices. Balancing digitalization with feasibility is necessary. Therefore, under the new rules, if providing electronic data becomes an undue burden for sellers, they can still issue paper-based receipts as before. The Ministry of Justice has published a Q&A on electronic receipts on its website, where we introduced the content explained earlier. Moving on to the topic of lease agreements for commercial real estates, the COVID-19 pandemic has significantly impacted the real estate market, leading to numerous inquiries regarding rental contracts received by the Ministry of Justice. For instance, in the event of decrease in sales due to the pandemic, if a tenant becomes unable to pay the rent for the currently leased property, do they have to vacate immediately? If a tenant's income decreases due to the pandemic, making it difficult for them to continue paying the rent, is it possible to negotiate rent reduction or deferment with the owner? If a tenant is forced to suspend business due to the pandemic, will the rent be reduced? Of course, these issues must be resolved on a case-by-case basis and ultimately decided by the courts. However, providing basic guidance on the fundamental principles of the civil law can be helpful. Therefore, the Ministry of Justice has created Q&A documents to answer these types of questions and made them publicly available on their website. Regarding the smooth operation of corporate business, before a shareholder meeting, a notice of meeting is sent to shareholders, and it's required to send them the balance sheet and income statement. However, it can be quite burdensome to create, print, and handle these documents before issuing the meeting notice. Especially due to the impact of the COVID-19 pandemic, there were concerns about delays in corporate accounting and auditing processes, resulting in the failure to prepare and print the balance sheet and income statement on time, and ultimately leading to the postponement of the shareholders meeting. To address this, the Ministry of Justice reviewed the regulations related to the company law and introduced the new measure. It stated that if the balance sheet and income statement were posted on the company's website from the time of the meeting notice until 3 months after the shareholders meeting, they would be considered as provided to shareholders, even if no actual electronic or paper delivery was made in advance. This measure was initially introduced in 2020 as a temporary measure, limited to 6 months as part of the measures to combat COVID-19. However, taking into account the practical needs and the evolving situation of the infection, it has become a prominent provision. In conclusion, the Ministry of Justice in Japan has taken steps to address the impact of the COVID-19 pandemic on various aspects of civil law. While I wasn't able to cover it today, I must mention that the Ministry of Justice Civil Affairs Bureau has also recently undertaken legal amendments to digitalize civil court proceedings with a focus on improving access to justice. The bill passed just a week ago. To align with the advancements in the latest digital technologies, the development of the legal framework is progressing swiftly. We hope that the initiatives taken by the Ministry of Justice in Japan can serve as a valuable reference for today's discussion as well. Thank you. That's all from me.
Thank you very much, Mr. Miyazaki. So I'm glad that it's not too late for you. Very good. Thank you for highlighting two interesting aspects that are really at the crossroads of two of UNCITRAL's frameworks, one on payments and the other one on electronic transactions. Thank you also for highlighting some aspects of contractual relationship and shareholder meetings. It's very useful, and we will of course have this reflected in the report. Now, without further ado, last but not least, from our government representatives, I'm giving the floor now to Mr. Ren Yu Kai. He's Assistant Director at Trade Trust, the Digital Utilities Sectoral Transformation Group in the Infocom Media Development Authority of Singapore. Over to you. Thank you. We can see your presentation very nicely, but we cannot hear you.
Thank you. Thank you. Apologies. Yes, thank you for the opportunity afforded to me by the Ministry of Foreign Affairs of Armenia, as well as the UNCITRAL Secretariat. My name is Kay, and I'll be taking you through this series of slides. So important. Okay, I'd like to first start off with a factual statement that trade is an important part of Singapore's economy. And in particular, maritime trade is a significant contributor to our economy. And Singapore is a grateful recipient of numerous international accolades on our role as a maritime and trade hub. With this context in mind, we then lit upon the fact that digitalizing the bill of lading, which is a very key maritime trade document, could greatly improve the efficiency and businesses involved in maritime trade. As an important, this important document called the Bill of Lading, it can be used to represent ownership of goods and are currently largely paper-based due to the importance of possession of the original document as a means to take delivery of the goods described therein.
Never mind, I fixed it, thank you.
Oh, apologies. Yes, let me continue. Now, manual processing of this paper document, as well as, what happens is that the accompanying trade documents also are in paper form as well, then results in high costs and friction points for all the businesses involved in international trade. As you can see from international studies, the number that we are talking about is not insignificant. We're looking at billions of dollars that the shipping ecosystem can stand to benefit from. Now, Singapore places high importance on harmonizing with international frameworks, as this helps our businesses to be interoperable with the global trade ecosystem, thus making it simpler and more certain for them. With this in mind, of course, UNCITRAL's work is extremely important to us. And in particular, the model law on electronic transferable records is what we needed to digitalize the bill of lading, or the original title document. And digitalizing this in a manner that is congruent with the Melita is going to help our businesses plug into a simpler and more predictable global trade environment. So in 2021, Singapore adopted UNCITRAL MLETR, or MITA, and we were amongst the first in the world to do so. And actually, this was with strong support from international and domestic stakeholders. In particular, the International Chamber of Commerce whom I understand there is a speaker from the ICC who will be speaking later on. The ICC had urged governments to adopt the Melita in April 2020. Now, in addition to achieving legal interoperability, I suppose, we also needed to help our businesses achieve that in the digital sense, right? And because for this reason, we set up the Trade Trust Framework. Now, the Trade Trust Framework is something that helps various systems and platforms to achieve three things across all of them. And these three things, or these three functionalities, are assurance of authenticity of a document, assurance of source of a document, and the transfers of performance obligation per a transferable document. Now, what is really interesting about the framework is that it is designed to support the commercially available and business-led systems and software ecosystems out there. And where we, as the Singapore government, come into play is to propagate these technical methods at international standards bodies like UNCITRAL, at ISO. And also, we have baked these technical methods into an open source, free for use, digital infrastructure or digital utility, which we have contributed to the world as a digital public good. This digital public good supports our various G2G initiatives and efforts around the world. Notable partners in this journey are the UK, the Netherlands, Australia, China, and so on and so forth. Ultimately, we must remember that the reason why we're doing all this is so that our businesses can benefit. It is so that they can enjoy more legal certainty with the digital medium. They can enjoy efficiency gains, and very importantly, lower the risk of fraud. And with that, I thank you.
Thank you very much, Kay, for this excellent presentation that will save me having to find practical examples. You've been perfect by showcasing and advertising for our Melita. So Melita, for those who don't know her, is the model law on electronic transferable records that has been dubbed Melita across the world, where it's being enacted now like hot buns. So thank you for this presentation that also illustrated the need and the benefit of the pandemic on modernizing and digitizing sectors of the economy that were lagging far behind, such as, for example, maritime transport. But this is also the case in rail transport, and we are working currently in UNCITRAL in our working group 6 on a negotiable multimodal trade document that will be electronic and will also be multimodal, including or starting with the rail component. So thank you very much for this. Hello, hello. Could you switch off? Could you switch off your microphone, please? Thank you. Thank you so much.
خلاص الحين أخلص بعد نص ساعة وأنزل وأطلع مرة واحدة أروق طفشت. والله.
Could you kindly mute? Why don't you click on mute all? Yes, thank you very much. So I'm turning now to the second panel of this morning's presentation, and I'm very glad to welcome all our partner organizations, the ones with which we work a lot in the field, because we, being a legislative body, UNCITRAL is not a technical assistance organization. And so in order to reach out to states and to help them in their technical implementation of UNCITRAL texts, we turn to these organizations that are either in the UN system or that are partners in the area of international trade. And one of these partners, which is actually a sister organization, is the United Nations Economic Commission for Europe, and particularly the UNCFACT that has been introduced already by the previous speaker. And I'm very glad to give the floor to Kamola Kuzhnuditova, the acting secretary of UNCFACT. Thank you very much for joining us, Kamola.
Many thanks for this kind introduction. Can you hear me well?
Loud and clear.
Okay, perfect. Thank you so much for this opportunity to present the work of the UN Center for Trade Facilitation and Electronic Business, and I will try to summarize its response to the pandemic. I represent the UN Economic Commission, which is for Europe, which is one of the 5 UN regional commissions of the UN Secretariat, and we're based in Geneva. I work in the trade facilitation section of the UNECE, and I lead the Secretariat of UNCFACT as its acting secretary. UNCFACT has a global membership, and its goal is to simplify and harmonize international trade and electronic business processes for the benefits of all. One of the comparative advantages of UNCFACT is that its standards are applicable to all modes of transport, and they're interoperable. Just to give you an idea of how we contributed to the crisis response, during the pandemic, we focused mostly on addressing supply chain disruptions, and in particular, we developed one of the recommendations, that is a recommendation on pandemic crisis trade-related response. Then jointly with UNCTAD, we have produced a report on economic recovery, harnessing e-commerce for the ECE transition economies. And there was also a number of training material that was developed during the pandemic as well, to facilitate the online access to our tools and to build capacity while being locked down. Now, we promote regional development and greater economic integration, and this subsidiary body of UNECE, we develop recommendations and electronic business standards for facilitating national and international transactions. And to give you an idea of what has been developed in the last 4 decades, UNCFACT developed nearly 50 policy recommendations and also 950 standards that are all available free of charge on our website and can be accessed by anyone. This is being developed by a community of UNCFACT experts that counts 1,600 experts around the globe. And they work tirelessly currently on 39 active projects, which are spread across 16 domains. And those different domains include trade and logistics, health, insurance, agriculture, to name just a few. Also, the work of CFACT is based on its program of work, and we work around achieving the SDGs, and also we align with the ECE Commission goals, which is the goal of the next 2 years is green and digital transformation. And the goal of the previous 2 years was the focus on circular economy and for sustainable development. So the work of UNCFACT is aligned with the UNECE goals and of course with the global goals, and this is how we respond to the global development agenda. Now let me go more into details about what has been done in addition to the recommendation that I had mentioned and to the joint report with UNCTAD. There has also been, and I believe my colleague from ESCAP will touch upon that as well in the next presentation, there is a joint initiative of the 5 regional commissions and UNCTAD. It's a global survey on digital and sustainable trade facilitation that is carried out every 2 years jointly. The last one was published in 21, and the next one is just about to be published in July 2023. And it includes the measures on trade facilitation, and actually the new one of this year will have 2 additional measures on e-commerce and wildlife. And the results are also available on the website, and you can see how the different countries are performing on that front. Also, another thing that has been conducted during the pandemic time, last year in 2022, we have conducted a business process analysis in Georgia that was looking at the export of pharmaceuticals from Georgia to the Central Asian countries. And this was extremely timely, and considering that Central Asia accounts for 50% of the pharmaceutical market for Georgia, that was really timely to identify the bottlenecks, to review the process, and we came up with recommendations that the Georgian authorities have been following since. So in general, we support countries by developing normative tools and guidance material, as well as policy advice and technical assistance. And this is, in a nutshell, what has been covered in the past few years. Now we are restarting again with a more in-person presence in countries, including the technical assistance. And this is something that we also collaborate on with different partners. The final thing that I will cover is the more of the standards that support sustainable supply chains. And we have a number of recommendations. And recently, actually, since the past 2 years, we have been also focusing on the environmental, social, and governance traceability work. And we had launched a team of specialists on traceability of sustainable value chains in the circular economy that has been set up since 2 years now. And it reviews the traceability policies and regulations, as well as the processes along the international value chains. So we do collaborate with a number of standard development organizations, including other regional commissions, ISO, World Trade Organization, and private standard developing organizations. But as I mentioned, our comparative advantage is that our standards are free of charge, they're accessible to anyone, and anyone can in fact participate in the UNCITRAL work. So you're welcome to join as an expert if you wish. In conclusion, I will just mention that our work is extensively referenced by different partner organizations, by policy tools. It's included in the EU regulation and directives. We are highly present in the 17 program countries of the UNECE, which are our beneficiary countries for the technical assistance and capacity building as well. I think I will stop here, and thank you very much again for this opportunity, and I look forward to collaborating.
Thank you very much, dear Kamola. That's a very, very useful panorama of all the work that is being carried out by UNECE. And I look very much forward to closer cooperation in the area of digitization of trade transactions. So thank you for that. I'm giving the floor now to Dorina Gitarou, who works for the EBRD, which is one of the organizations with which we are working consistently in several areas of UNCITRAL's work. And I'm very glad to give you the floor. You are the acting counsel in the Legal Transition Program. Over to you, Dorina.
Thank you, Anna. First of all, thank you very much to the Ministry of Foreign Affairs of Armenia and UNCITRAL for the organizing this event and for inviting us. It's my pleasure to give you a brief overview today on the EBRD's work and in particular legal transition program work on the public procurement reform. We have a long-standing, very productive and fruitful cooperation with the UNCITRAL Secretariat on implementing the public procurement reform in the countries of operation for more than 12 years now. And we are mainly focusing on promoting the legal reform, but also on providing the necessary implementation instruments and tools for the governments, because we all know very well that it is one thing to just have the necessary legal framework, but it's much more efficient to ensure this implementation and this working in practice. And for this purpose, in the past years, and particular in pandemics and in the post-pandemic era, to put it this way, it has been very productive to have implemented the digital approach and the innovative multi-platform networking system that EBRD has been working on for quite a while, and that has successfully implemented in the number of countries of operation. So it's needless to say that obviously the UNCITRAL model law on public procurement gives us great instrument that can be tailored up to the needs of any country, regardless of any other basically international or regional commitment that a country may have. UNCITRAL with model law would provide a possibility and opportunity to fine-tune and to identify the instruments in order to meet any requirements, obviously promoting the value for money, efficiency, high competition, transparency, openness, and procedural fairness. And we are working together with a number of partners besides UNCITRAL, including World Trade Organization, Government Procurement Agreement team, and also the Open Contracting Partnership, promoting just openness and open standards in the implementation of the respective tools. That's why for us, the cooperation with the UNCITRAL colleagues is a valuable one, because UNCITRAL gives this opportunity to meet at the same time the WTO GPA requirements like the EU directives, giving enough space to put the digital instruments in the proper level, and to implement the open contracting data standards that creates a perfect harmony, I would call it this way, between the government requirements, business requirements, civil society requirements, just to have at the same time the needed access to information, the required level of transparency, the required level of competition, at the same time giving proper instruments both on the government but also at the business side, and what is more important, promoting international competition and international openness, just giving the opportunity not only to national suppliers, including SMEs, but also to international suppliers to bid on the corresponding public procurement markets. And for this purpose, in creating the a new digital solution that could be easily tailored up to the needs of any government. So we put an emphasis on the flexibility of the architecture of the proposed solutions. We obviously put a strong emphasis on the open source technologies that obviously reduce the cost of developing such an instrument, and EBRD has implemented a number of such kind of solutions in the countries of operation. Also, we focus on the event-driven processes that would streamline and would just ensure following the rules and procedures without being it complicated on the user side, including the contracting authorities and buyers. Obviously, at the same time, the new digital solutions have a very strong security level requirements implemented. And as I mentioned, Open Contracting Data Standard, so OCDS, is in the core of the new digital solutions. So we don't rely on the OCDS only at the publication level or the openness of the data, but we implement OCDS in the transaction level, so at data exchange level. So basically it is built in the system, and all that is done in a control environment. So to highlight the collaborative digital public service between governments and business, so they rely on a very efficient, open collaboration between the public buyers, the suppliers, the civil society. We have commercial platforms integrated and ensuring basically the whole process, while at the government level, there is a government central unit that ensures the exchange of information and data with all required, including the control bodies, including the audit service, the review body, the state treasury, all available electronic governance services, and all this is done via an OCDS API. Just for the sake of time, I would just highlight one of the main success stories already in the countries of operation, and I would like to highlight the M-Tender, which is the electronic public procurement system of the Republic of Moldova. And luckily in Moldova, there is well-developed e-governance services. So basically, it is possible to have the interoperability of the e-procurement system with all government services, including electronic payment, including automatic check of the situation in all government registries, and so on and so forth. And another example I would like to highlight the Prozoro that goes beyond and in Ukraine's procurement system. So we have besides so we have like a wide environment, and besides the public procurement system, there is a Prozoro sale. So basically that ensures the electronic sale of public assets, and then we have an extension of the Prozoro services by including the functionality for concessions and PPPs, and so on and so forth. And currently we are actively implementing another digital support and new procurement system in Uzbekistan and some other projects in the countries of operation. So this obviously helps a lot governments to overcome on the consequences of the pandemic, but also in the eventual other unforeseen and unexpected and unwanted cases. So there is a great support just having everything digitalized, interoperable, and just saving time, money, and giving efficiency for the government spending, but not only, as I mentioned. So we expand this to a number of other areas. So thank you for your attention.
Thank you very much, Dorina, for showcasing so efficiently the digitization of public procurement and the way it has enabled governments through emergency procedures and also through the digitization and the use of platforms to be able to continue to procure, including during the pandemic, where for example, the procurement of vaccines and other necessary health and medicine was extremely crucial. So indeed, thank you for this illustration. And now I'm giving the floor to Jan Duval, a long time, I was going to say old partner of UNCITRAL, but I shouldn't say old, a long time partner of UNCITRAL, working on paperless trade, and from there showcasing the importance of digitization in the trading and the transactions. Jan, over to you. Bonjour, Jan.
Bonjour, bonjour. So thank you very much. Thank you to Armenia and UNCITRAL for organizing this event. I have a few slides to share. I will try to keep within time because I know there's a lot of speakers. But yes, indeed, I will focus on paperless trade facilitation. So let me just start this. I hope you can all see the slides. So, I mean, this is an interesting topic, and indeed there has been a big impact of the health crisis and COVID-19 in particular on trade and trade facilitation in the Asia-Pacific region from ESCAP perspective. So let me first start by mentioning this UN Global Survey on digital and sustainable trade facilitation that was also mentioned by Kamola. This is coordinated by ESCAP, and it's a joint initiative of all the UN Regional Commission and UNCTAD. And what it does is that it takes a snapshot every 2 years of the implementation, state of play in implementation of digital and sustainable trade facilitation measures. And so what we found is indeed that if you look at what happened during the COVID-19 crisis, during the health crisis, you found that the implementation of trade facilitation measures actually increased faster than previously. So because of the supply chain disruption, not despite, like written on the slide, because of the supply chain disruptions, I mean, countries turned to how they could simplify procedures and so on to keep trade going. And so implementation of trade facilitation measures increased significantly between 2019 and 2021. And this is particularly true of paperless trade and cross-border paperless trade measures, as you can see on this slide here. So we distinguish between paperless trade and cross-border paperless trade in the following way. Paperless trade is about the electronic exchange of data and documents within the country, so between, let's say, the customs and the traders within the country. But cross-border paperless trade is really the electronic exchange of data between countries and between authorities across countries, which is significantly more challenging, as you can see on this figure here. The implementation rate of cross-border paperless trade facilitation measures, although it increased during the crisis, is significantly below that of other types of trade facilitation measures. I can't go into detail, but certainly cross-border exchange and legal recognition of electronic data and documents is still lacking, although there's been a lot of progress during the COVID-19, and it's really and country realize, how important that issue was, because it was very much more difficult to exchange paper document during the COVID-19 crisis. So if you can see in this slide, countries have worked on laws, on developing laws and regulations for electronic transactions, in many cases using UNCITRAL instruments, but still there is a lot of work to be done. So how do you move forward on cross-border paperless trade? There is quite a number of issues to be addressed. So international standards development, so that my colleague from UNCFACT, from UNEC is taking care of some of this. And then there is also, as one of the issue, harmonization of legal framework so that the electronic data and documents can be recognized across borders, including electronic signatures and so on. And this remains quite a bit of a challenge. So what has been done at ESCAP already for the past 10 years now, it's for over 10 years, took over 10 years to get to where we are now. But there is a UN treaty on dedicated to cross-border paperless trade facilitation now, called the Framework Agreement on Facilitation of Cross-Border Paperless Trade in Asia and the Pacific, CPTA in short. And so actually this treaty entered into force in 2021, so in the midst of the crisis, as that's in China and Bangladesh joined that year, became parties that year. And again, it's a sign that there was realization that there was a need to accelerate cross-border paperless trade and the electronic exchange and legal recognition of trade data and documents. One thing I wanted to show you about the CPTA is some of the general principles that are driving the implementation of the CPTA. And I mean, all of you are familiar with UNCITRAL documents, right? You can see already recognize some key principles underlying some of the electronic commerce model laws and so on. Functional equivalence is there. Technological neutrality is there, and some others as well. And so there is full consistency between the framework agreement and the UNCITRAL instruments, which doesn't come as a surprise because UNCITRAL has been involved in the development and the negotiation of the treaty from the very beginning. So what happened also during the crisis is actually we saw, or just at the end of the crisis, countries actually joined the treaty. So now between 21 and 2022, we saw a 100% increase in the number of countries who acceded to the treaty. So now we have 11 parties, 11 member states fully on board the treaty, and several others, in particular from Central Asia, are going to have told us that they will come on board later this year. So it's a very useful tool to demonstrate high-level commitment to digital trade transformation and to enable cross-border paperless trade. So you've got the list of countries here, and then you will know that Armenia was the very first country to sign the treaty, but hasn't ratified it at this point. So we look forward to this. In fact, this is my concluding comments. I mean, COVID-19 crisis did highlight the importance of accelerating trade digitalization. I think this is well recognized in actually the toolkit that I've seen, right? Associated with this event today. UNCITRAL instruments related to e-commerce have supported the development of the CPTA, and we expect that UNCITRAL instruments will support very much the implementation of the CPTA going forward. And a good example that was already mentioned is MELITR or MELITR, depending on how you want to pronounce that, right? Because that's a key issue in cross-border paperless trade. We expect to continue ESCAP UNCITRAL collaboration in this area. And again, I'd like to encourage all the countries participating to consider acceding to the CPTA as soon as possible. We've got meetings coming up next week, a big series of meetings, including one workshop on cross-border legal recognition and technical interoperability of trust services in collaboration with UNCITRAL and Digital Standard Initiatives of ICC. And so you're all welcome to join this online if you can't make it to Bangkok. And at the very last point I'd like to make, and this is unrelated to what I mentioned before, I just want to flag for those of you who are somehow involved in negotiation of trade agreement and regional trade agreement, because this is legal as well, you may want to check out this initiative on model provisions for trade in times of crisis and pandemic that ESCAP led in the midst of the COVID-19 crisis. And there is a model chapter on trade in times of crisis that was produced as part of this initiative that I won't go through, but that may be of interest to some of you, but it's not commercial law. So that's why I haven't really gone into a lot of details on this one. Thank you very much.
Merci beaucoup, Jan. Thank you for showcasing the paperless trade, which was an ongoing initiative for a couple of years that has really been boosted by the pandemic, and we could see, and we were very happy to be part of this very important treaty that has been negotiated and that is now being joined by many countries to become part of this paperless initiative. So thank you very much for that. And last but not least, I'm turning to our representative from the ICC, who's our strong advocate with the private sector on the use of UNCITRAL texts. I'm very glad to give the floor to Tianmi Stilpen, who's the lead in regulatory affairs in the ICC at the Digital Standards Initiative. Over to you, Tianmi.
Good morning, good afternoon. Before I begin with my presentation, I would like to take a moment and extend my sincere gratitude to the Ministry of Foreign Affairs of Romania and also UNCITRAL Secretariat for hosting this very important and also timely event. It is an honor to stand before such a distinguished assembly of experts from various domains, all united by a shared commitment to fortify international trade. My name is Tammy Stilfen. I'm here to talk about an initiative that was conceived in response of the challenge thrown at us by the COVID-19 pandemic. I am from the International Chamber of Commerce Digital Standards Initiative, abbreviated as ICC-DSI. ICC is the institutional representative of 45 million companies in more than 170 countries, making it easier for business to trade internationally. And ICC-DSI aims to digitalize global trade by promoting policy reform and harmonizing and driving the adoption of digital trade standards. Before the pandemic, as a consumer, you may have felt the cross-border transactions were easy or even maybe seamless, especially in the realm of e-commerce when you buy things from abroad and it ships to you with all the custom tax and shipping all taken care of, and you probably get your package within 2 to 3 days, or even longer, like maybe under 2 weeks, right? But the reality is a cross-border transaction involves multiple actors, on average requires the exchange of 36 documents and 240 copies. Despite the ongoing digitalization efforts since early 2000s, in 2020, only fewer than 1% of the trade documents are fully digitized. Most documents require white ink signatures and physical possession of the original authentic document to be transferred at the time with the cargo to transfer the ownership or rights of title. As we all witnessed, the COVID-19 pandemic severely disrupted the supply chain and trade flows across the globe. I was based in the US prior to relocating to Singapore. During the pandemic, many ships carrying imported goods arrived, but we didn't have the appropriate people to sign off on the paperwork to offload the containers. Imported goods were on the back order and next scheduled shipment doesn't even leave the origin until months later. Items on the grocery shop shelves were depleting without restocking. And at one point, I think US was running very low on aluminum cans. And you can imagine how difficult it must have been for soda drinkers. Another example in the US where I personally felt that the impact of broken supply chain was that since we couldn't travel, a lot of dispensable income were put towards home improvements. From the wooden floors to sinks, tiles, and the shower curtains, often took 7 to 8 months to order. And even with this long window, the demand was still very high because the structure is set up in the US in a way that all the material costs were calculated together with labor. So you couldn't really commence the housework until all raw materials has been ordered. So this, you can see the intertwine between any business model in anywhere around the world tied to a global supply chain. So I think I've provided a glance of actual impact, which is more than just simply grocery items being impacted by the broken supply chain. It affected us almost in every facet of life. Lockdowns and mobility restrictions reveal the vulnerability of our traditional paper-based trade system. The urgency to adapt and innovate was never greater. The previously inefficiencies of cross-border trade, long considered a mere inconvenience, officially became a crippling obstacle in a crisis scenario. It was within this context that International Chamber of Commerce conceived the Digital Standards Initiative in 2020, aimed at improving these longstanding efficiencies and facilitating seamless global trade in the midst of global disruptions, starting with an enabling legal environment. Given these obstacles, many trade parties to a transaction sought out private law contracts with increased closed loop trading platforms that allow these trade documents to be transferred instantaneously. But as a result, organizations must adopt many different or multiple products for consumers in different jurisdictions to enable the transfer of electronic records. The inefficiencies and high cost to subscribing to every single platform were very evident. And on top of all these prohibitive factors, there was one overarching concern, which was the lack of legal certainty. These platforms are still private law solutions in nature and parties are held to their contractual obligations, but they can't trade with the certainty of knowing that country A, who I'm trading with, does recognize the legality of ETRs or electronic transferable records. The three main principles of MOETR, as we mentioned just now, briefly touched, was the non-discrimination, functional equivalence, and technology neutrality. which really provided an enabling regulatory environment for importers and exporters, additionally embracing cutting-edge technologies such as registration tokens and distributed ledgers. We often felt that laws were not catching up the speed with technologies, but this enabling framework does not discriminate against any technology, and it remains neutral towards any solution that you feel like choosing. As we said, one major concern and also topic for today was the legal certainty, right? How relevant was this? A colleague from UNCITRAL earlier today, and also as well as a good friend of DSI, Luca Castellani, shared a 2023 case with me. The name was UniCredit v. Euronav, was on the mischarging of a finance cargo without the presentation of a bill of lading. And I guess the moral of the case was that this could have been avoided with the electronic bill of lading. So by adopting MOETR, you are increasing the clarity on the legal validity of ETRs and also reducing the likelihood of disputes, not only during how this would be resolved, but also reducing the occurrence of it. Having more confidence for traders would really drive trade volume for any given country, and harmonized rules and talking about interoperability provides a more certain legal environment. And it's really, like, for example, easier to determine who is responsible for the record in case of the dispute. And also, like I said, there's the additional layer of authenticity where you can use your choice of tech provider to really add that additional layer of security and reducing the likelihood of disputes, and also reducing documentation fraud through various means. And as I introduced, we are a representation of 45 million corporations. This will be huge for SMEs to leverage, for not only for them to reduce all the costs. As you may recall, at the advent of a digital age, a lot of the costs were driven down, so we can break down the barriers built by capital corporations. But now that during COVID, it became evident again that a lot of the businesses needed heavy startup capital to really drive that business model. But with MOETR's enabling, we can definitely bring more SMEs into the global trade realm and also let them enjoy trading without the the legal environment concerns that I've just described. Also, it simplifies operating models and risk profiles of all shippers, customs department, banks, and buyers and sellers. So just more than just importers and exporters. Lastly, it incentivizes new business models and greater global inclusion. So there are now 7 jurisdictions that have adopted or aligned to the MOETR framework, and some of them have enabled a completely different and new business model because of the MOETR. For states, we are taking back, like I said just now, a lot of the closed loop platforms are still private law solution. We're taking back the private law solution back to the public hands and providing more legal certainty, and also promoting a very interoperable documentation environment for all trading partners, and maybe even sparkling new trade relations in the midst of all of this, and encourages modernization of business models, increasing market efficiency and technology advancements, and helps countries to better achieve their UN SDGs. With the help of our Legal Reform Advisory Board, we engage with government to host capacity building sessions to implement and benefit from digital trades, including hosting introductory sessions to raise awareness about conducting domestic analysis to evaluate how a country can align to the MOETR framework. With their help, we're able to reach governments, industry associations, multilateral organizations, and regional economic communities. The amazing speaker just now, Yan, and also the organization that Dorena represents, EBRD, are both esteemed member of our Legal Reform Advisory Board. Our goal is to have 60 to 80% of world trade to be MOETR enabled by the end of 2026. It's a quite ambitious goal, but this is, I think, where everybody comes in and really face the challenges that are posed by the COVID-19 pandemic, but also it is a chance for us to regroup and gather ourselves to discuss our responses to global crisis, but also to prepare for the future of digital age. That concludes my presentation. Thank you.
experts that we listened to and their practice, what they did for MSMEs or other sectors of the economy during the pandemic, and what the private sector can do, and how the two really have to work hand in hand and to transform the lessons that we have learned into a more conducive framework for international trade. So with that, I'm giving over to my co-moderator to introduce our last speaker, the one we should have started with to set the economic stage, but it's not too late to listen to all the things that have happened in the area of international trade during the pandemic. Thank you.
Thank you very much. And yeah, indeed, we're now transferring to the last keynote speaker address and relating to the measures impacting on international trade, the economic aspect, and the presenter will be Mr. Jan Hoffman, Chief Trade Logistics Branch, Division of the Technology and Logistics at UNCTAD. Since 2016, the branch is implementing multilateral transport and trade facilitation capacity building programs, as well as regional and national projects in Africa, Asia, and Pacific, and Latin America and Caribbean. Mr. Hoffman is a co-author and coordinator of the annual UNCTAD review of maritime transport, created and co-edited the quarterly UNCTAD transport and trade facilitation newsletter, and initiated UNCTAD maritime country profiles and the annual linear shipping connectivity index. And without the delay, I'm passing the floor to Mr. Hoffman. Please, you have the floor. Thank you.
Yeah, thank you very much. Would have loved to be with you in person, but there we are, connected through Zoom. Thank you for this kind introduction. Thank you for this initiative. Let me go straight to the share screen function then and share with you what we had agreed I would discuss. Some post-COVID trends in international trade, supply chain, logistics. I hope you can see everything. I hope you can hear me. I also hope you will understand me, because a lot of what I will say is economics, as I was asked. So I'm not a lawyer, and I hope what I say will make sense to you. I will speak about long-term trends before Corona, like BC, then discuss, explain how we see it, what happened during Corona, and finally some long-term perspectives with a view of this legal regulatory framework issues. Let's start with some long-term trends, really the big picture. We have data for decades, international, sometimes national. This chart, for example, is data for the United States, but it is, I find, very illustrative for a global trend, where you see that over the years, the economy is spending less on inventory holding and more on transport. This, for me, is an indicator of efficiency. We have better trade facilitation, faster, smoother processes, just-in-time deliveries, containerization. All this together leads to a decline of this expenditure on inventory holding and a higher share of expenditure on transport. That does not mean that transport is more expensive. It simply means because it's getting better and more efficient, I buy more of it. The second long-term trend globally is that, like this part of globalization, goods travel further, longer distance. Here, again, a lot of the data I'm sharing with you is on maritime trade, because that moves 80% of global volumes. It's the big picture. And also long-term, it depends a bit whether it's oil or dry bulk or containers or general cargo, but generally the distance has been increasing. Then the third and last big picture trend I want to share is the participation of developing countries. It's a somewhat simplified picture, but when I went to school, I was taught that the global south exported, that's here the red bar, the high volumes of raw materials, and imported low volume, the blue bar, the unloaded, imported goods of manufactured goods. They were higher value, more expensive, but lower volume. Today, the geography of trade has totally changed, and developing countries as a group, including China, of course, but also Vietnam, South Africa, Costa Rica, are also importing. So we no longer have this simplified north-south division of labor. So that's long-term trends in trade and logistics. Then came COVID-19. What happened during Corona? For this context here, I just want to start highlighting how the freight rates in container shipping went through the roof. Now you see this long-term trends of a little ups and downs. The red line is the freight rate that you and I pay when we import containerized trade. The blue line actually went up even further. This is what the shipping lines, the Maersk, the MSCs, the Costcos of this world, what they pay when they charter a ship. Because when you see a ship that says Maersk or MSC on the side, probably about, well, there's a 50% likelihood that this ship is not owned by that company, but it is chartered in from an owner. And that also went through the roof. So here comes The Economist. Thank you in advance for your patience. So an economist loves demand and supply curves. And the demand for transport is very steep, very inelastic. That's how we call it. So you see, the freight rate needs to change a lot to have a small change in volume. This is how we like to illustrate this. So on the left, you have the freight rate. So you can imagine you need to have a big change in the freight rate to have a small change in demand. In fact, in the very short term, this is almost vertical. It is very, you really, really want this iPhone for Christmas, whatever it costs to transport. You really need this fuel to drive your car. You really need this iron ore to produce. The price of transport is always only a small part in the final price of the good. On the supply side in shipping, and this may be new to you, the way to present this, but this is a way to present that there are capacity limits. So when there's enough capacity, prices can be very low for a long time, and there's not much so-called elasticity. The moment you need 20 ships or containers or trucks, but only have 18 or 19, and you really, really need this good now, and transport is still only a small part of the final price, it's like going at Christie's and selling to the highest bidder. Freight rates go very fast high through. So what happened during COVID? These meet, these two lines, and then we had the demand going to the right, and was very nicely presented by Tian-Mi just now. What happened during COVID? We ordered other things online. We were at home and no longer went to the restaurant, hairdresser, movie, travel. So that went to the right. Supply went to the left because ships spent 20% longer in ports and other things, and congestion and border crossing and so on. So freight rates increased fivefold. This did have impact on prices. We simulated 2 years ago that prices will increase due to these higher freight rates. People were quoting what I just said before, said, oh no, but it is still only a small part of the final price. Yes, but come on, if it goes up 5 times, it is not nothing. No? So there is an impact on the prices. Well, what happened now, more recently, we are back to before, almost. They're still somewhat high. Some thinking about long-term perspectives. What happened during Corona? What are the impacts? And I think what I'm saying here builds nicely also what Jan, the other Jan, the one with Y, said on more demand. But so on the supply chain, actually during the crisis, expenditure on inventory holding went up. The chaos, the wrong goods were ordered and wrong place. No, we do see a trend more back to the long-term trajectory now. So I think this is an important message here, thinking, we hope that most of what happened was a hiccup, and we are now back to a longer-term trajectory towards improved efficiency. Same with the distance. We did see maybe for some goods, some nearshoring, but now the latest forecasts are actually further increase in the average distance travel, including oil, grains that for different reasons now go longer distances. The share of developing countries, for the first time since we looked at it, had slightly decreased in imports. Again, latest data we have, it is back to increasing. Who leads the IT reforms in your company? The CEO, the chief technical officer, COVID-19. Again, in line with, I think, what Jan Tianmi just said. So when the crisis started, and well, actually already before this, we like to say technological progress will never be as slow as today. Is it slow? No, it's not slow, it's fast, but it's going to be even faster. So we have exponential growth. You see all this AI growth. We could go on hours about this fascinating topic of artificial intelligence. On the issue of legal framework, national, regional, global, the negotiation, ratification, implementation of conventions take time. We need to commit to whatever is the best future technological solution. I could tell many anecdotes where reluctance, waiting, doubts during the negotiations, for example, of the trade facilitation agreement, were totally taken over by technological developments. So some of you may have a favorite football club, favorite singer, or favorite restaurant. I have a favorite article in the WTO trade facilitation agreement, 10.1. Jan Hoffman is a fan of Article 10.1. All the other articles and measures, there are like 37 measures and 12 articles. We can say that in 10 years, maybe in 50 years, but they will be done. We will say, yes, I have an advanced ruling. Yes, I have the single window. Yes, I have the internet. Yes, I have the transit arrangement. Yes, I have the pre-arrival process. This one will still be valid in 100 years from now, because we will always continuously continue to minimize the incidence complexity, review requirements, reduce the time, and always apply the least trade restrictive measure. So in sum, I was asked to be very brief. We are already a bit behind time, so I was rushing through this. I shared with you like some long-term trends. I showed you the best picture you have ever seen that explained what happened during the supply chain crisis. And then went on discussing two issues like the future trends in global supply chains, but also the surge in demand for digitalization, for solutions in terms of that require the correct legal and regulatory framework. A lot of further reading here. Could have gone through each one of these publications in detail, but happy to connect on LinkedIn, happy to respond to emails. I have shared this PowerPoint. You can have some further reading, and I happy to answer any questions if we have time. Thank you.
Thank you very much. Thank you, Anne. It was very interesting to follow the presentation. It's good that we'll have the presentation shared with the extra reading materials. And thank you for sharing your insights about the long-term trends, about what happened, and also future predictions, some projections. That's also what needs to be done also to somehow prevent similar scenarios in the future if we are facing a similar COVID-19 like emergency or pandemic. Thank you very much. I think we don't, we don't have time for further discussion. I think we're like, I think we'll do the discussion session in the afternoon. And now it's already time for us to have the break. So the lunch break. And thank you all for your kind attention and participation to the speakers. And yes, we'll often come back at 3 p.m., right, to this room. Thank you very much, and we'll be connected. Thanks. afternoon session is the legal toolkit on effective use of UNCITRAL instruments. And actually the role of the UNCITRAL instruments mentioned during the first session of today's event is to ensure the progressive harmonization and modernization of the law of international trade. This mandate is pursued through the use of an adoption of legislative and non-legislative instruments in key areas. And as you can imagine, a key area of the practice dealing with the representation of state interests before international arbitral tribunals and international arbitration is existing actually in Armenia too. And actually it's very relevant for the Armenian realities too. And it will be very interesting to hear the insights. And I'll pass the floor to Anne Jobin.
Merci beaucoup. Thank you very much. So I'm going to introduce now, after all these very interesting sharing of experience and practice by states and also by international organizations that have all been trying to help and to find ways of mitigating the crisis. We're going to discuss the UNCITRAL toolkit as it has been structured, and that is going to be discussed at the Commission session. So the first part of the toolkit, and the toolkit is structured in 3 parts, is really to discuss the responses by states during the COVID-19 pandemic and the consequences of their respective responses. So you've heard during the morning session state representatives sharing legislative practices on responses and resilience, and international organizations talking about their responses. And you can see that all these measures are multifaceted, and they also show the many areas that the COVID-19 pandemic has impacted. We have heard about measures that enable businesses to operate as efficiently as possible, as normally as possible, but remotely. And we've also seen the measures taken by states to prevent negative consequences, and that was particularly highlighted by the Russian Federation when speaking about the moratorium on insolvency, and also to help MSMEs and contracting parties reducing disputes as much as possible. But we've also seen that it goes way beyond these 3 main areas, and that there are different measures and experiences that states have shared that can help in mitigating and creating a stronger economy to be able to face whatever forthcoming pandemic, God forbid, or any other similar kind of disruptions to international trade. So these instruments that you've seen are being classified in our toolkit under 3 main headings, and the first heading is you have to go a little bit further, Marianela, if you kindly could move us to slide 16, that would be very nice. No, sorry, I'm still on part 1. No, so no, go back to part 1 of the toolkit, and we will start with the measures that states have sought to respond to. And here we've seen that among the measures and the disruptions, there have been there has been a first consequence and response in the terms of digitization of trade. And here we've heard about the need for remote, virtual, online participation in meetings. We've heard from Japan the information about a very specific issue, which is shareholders meetings. We've seen also the need for the functional equivalence of electronic documents to physical documents, and that's something we will be explaining more in detail when we reach the digitization of the economy. And we've also seen that in a number of, from the responses of a number of states, there have been measures to promote the use of electronic signature and electronic authentication. That is something that I was quite surprised, being more from the dispute resolution side, to see how not advanced the to put it mildly, the dispute resolution industry and practice is with regard to any of these digital tools, and how reluctantly it has taken on board these new technologies in discharging its role of dispute settlement organizations or institutions. We've also looked into public procurement, and here we had a number of exchange or presentations, particularly on the amendment of procedures from the Czech Republic or from Italy. We've also seen how much MSMEs have been at the heart of the measures taken by states. We've heard it from Argentina, Indonesia, Kyrgyzstan, the Russian Federation. Through tax breaks and exemptions, we've seen direct financial assistance and subsidies. We've seen a strengthening of the loans and the possibility to access to credit, and the deferral of repayment of loans that were provided by some of the states. We've also looked, or we've received in this first part of the toolkit and presented some experience regarding modified insolvency regimes to reduce or to suspend the negative effects of COVID. And we've seen here simplified insolvency regimes being really picked up. And it was very concomitant with UNCITRAL's work on the MSME or the MSE, because we didn't deal with the medium-sized. We really dealt only with micro and small enterprises to introduce simplified insolvency procedures, and also a strong trend of amendment of insolvency laws and procedures. You can see that a number of states have actually enacted these amendments to respond to the crisis. And finally, we also looked at legislation impacting contractual relations. And we could see that, for example, some countries have allowed relief from legal and enforcement action for individuals and businesses that were unable to perform contractual obligations. Very interestingly, that was one of the first measures that Singapore enacted with regard to suspending because of COVID, the effects of contracts, the limitations or capping of interests, as well as suspension of limitation of periods and extension of procedural periods and deadlines. So that was, if you want, in a nutshell, the different areas where we have gathered responses by states. Of course, we have received also many more responses, but relating to issues that are not within UNCITRAL's purview. For example, when it comes to measures at the border, to restrictions or to reinstating restrictions at the border, these are more within the WTO arrangements and not so much at the transactional level, which is UNCITRAL's mandate. So we're moving now to the second part of the toolkit, which looks at UNCITRAL instruments. And you've heard this morning a number of instruments being cited. Of course, MELITA is the big star, but there are many other instruments and texts that UNCITRAL has enacted over the years, or have developed and made available over the years, that are perfectly suitable to respond to some of the elements of some of the disruptions that we've seen occasioned by COVID-19. So just to give you a quick overview of the texts. So we have identified texts in the area of international commercial arbitration, international commercial mediation, with a view to making shorter and more and less costly procedures available, especially to small and medium enterprises when faced with disputes during this period. Of course, as I mentioned this morning, our flagship convention, which is the Convention on the Sale of Goods and Related Transactions, which in fact sets default rules that can kick in case parties have not in their contract included some of these provisions. And that's particularly the case, for example, for force majeure. The procurement and public-private partnerships, two of UNCITRAL's frameworks, one on public procurement where we have a model law. We've heard explained by the EBRD what has been done in this context, and also public-private partnerships where we have a legislative guide. The entire framework developed for micro, small, and medium-sized enterprises is completely relevant. And of course, and we will enter more into details, is electronic commerce. Insolvency, we've heard about it as well. Security interests to strengthen access to credit for small and medium enterprises, online dispute resolution, international payments, and the international transport of goods, where again, for historically, let's not forget that UNCITRAL has been working for almost 60 years now, developing texts in some of these areas. For example, international transport of goods or sales of goods is something that, you know, has been developed recurrently over the years. So what we have identified then is these instruments. How can UNCITRAL instruments help in times of global emergency? And here, what we looked at was the degree of adoption and enactment of these texts that can be either adopted without any modification or reservation, adopted with modifications or reservations, and very oftentimes you see that with model laws that they have their domestication, if you want, to make them also apply to the reality in the jurisdiction. That they can also be used because in spite of not being formally announced, the legislation that is or not being formally referring to UNCITRAL text, the legislation is similar or identical to UNCITRAL instruments. And of course, there's the case where these legislation are not yet adopted. So let's go first to the first and very strong area where UNCITRAL texts are perfectly relevant and perfectly useful for cases of global disruptions like the one we've just seen, are the ones that strengthen the digitization of the economy and that produce or that set up a conducive framework for digital transactions. Very simply, from the examples that we've heard this morning, it's easy to understand that when you have a bill of lading that is composed of 130 pages that need to be scanned or that need to be photocopied, that need to be stamped, that need to be signed, that need to be sent by the post so that they arrive hopefully before the ship arrives, that this is of course totally impossible in a time of lockdown and in a time of crisis like we've experienced it, and that it is necessary to have recourse to electronic means. But it's important to say that these electronic means can only work as far as they are legally accepted and that they are legally recognized as being the equivalent of the paper forms. And so that you can do only if you have this infrastructure legislation in place, which can be, which derives very clearly and almost automatically from the adoption of the model laws on electronic commerce, on electronic signature, or on electronic transferable records. What is this MELITA, this MELITA all about? It is about non-discrimination, as we've heard this morning. It's about functional equivalence. The same function can be carried out either through paper means or through electronic means. And of course, the technological neutrality, which is really at the heart of UNCITRAL's work on electronic commerce and now on digital trade. The other text that is really very important as a basis, and that a number of countries have actually put into their parliamentary program as a result of the pandemic, is the Convention on the Use of Electronic Communications in International Contracts. So the same thing, it allows you through the convention to recognize any electronic forms of contracting, and that, oh, thank you so much. You're saving my life. Thank you. For those who listen online, I have found my glasses again, and I'm so grateful because I can see what is on the screen. This is wonderful. Thank you. So this convention, again, is a founding text for the digital economy, or for at least electronic commerce when it was designed. And now we are reaching the stage of moving from electronic transactions into actual digital transactions. And what is necessary there is that there are additional elements or additional actors in these transactions. I'm talking here about the platforms. When you're talking about electronic commerce, it is simply a means. It is a way of transacting. You're doing this through electronic means, through electronic transfer of data to electronic signature, electronic forms, and that's more a vehicle. What we are seeing now is the development of a completely new economy, which is based on digital tools, digital technologies, digital means, and where it is important to, and that was really, that is really a founding text, to be able to identify and to authenticate who is performing this transaction. And that can be done either through the first part of this model law on the use and cross-border recognition of identity management, which is the one that establishes the criteria that will contribute to a cross-border authentication, whatever the format of the digital identity, whether it's given by a government to its citizens, or whether it's given by eBay or by Amazon to its customers. It's the same criteria that allow you to authenticate that it is Mr. X buying from Mr. Z. And that is the first way. And the second is to have recourse to trust services. And these trust services, as you can imagine, during the pandemic have really developed exponentially, and you have now more and more services that allow authentication of transactions and of players in transactions. So this is, if you want, the strongest of our framework, in the sense that it is comprehensive. It goes from the early electronic signature through the electronic transferable records to electronic means of identifying the actors of the transaction, even when it's taking place through a platform. And what we are now developing, which we think is also maybe not a consequence of the pandemic, but I think has also benefited from a boost of interest, is the development of artificial intelligence. We've never heard so much talking about artificial intelligence and machine contracting. So that is what we're working on in Working Group 4 currently, artificial intelligence in contracting. And the second pillar, I think, of the digital economy, which is data transactions. So what we are working on currently is giving legal certainty to data, which is being exchanged for billions of dollars every day, and which, to our knowledge, doesn't have a harmonized and secure legal framework to identify what are the responsibilities of those who sell, those who buy. And so that is what we are working on. Let's move now to the next framework, which is also an UNCITRAL framework, which, as our friend from the EBRD presented, is very much developed and further developed with the EBRD and also with the WTO. It is the UNCITRAL model law on public procurement, which enables and allows e-public procurement. So the electronic means in public procurement have been really well taken on board, including in this framework, and emergency procurement, which was one of the important, which was one of the needs during the pandemic. To have that in place made, of course, the whole procurement by government a lot easier. Let's move now to the work on supporting MSMEs. And here we have different texts on MSMEs that are available already and who allow to support and to direct the legal framework to MSMEs. And we had here particularly the model law on secure transactions that was used as an element of the text on access to credit for MSMEs. It's one of the means for MSMEs to access to credit. There are already legal principles on a legal guide on key principles of a business registry. And we have the legal guide on insolvency for MSEs. And I'm going to give the floor now to my colleague Marianella to tell you more about the insolvency framework of UNCITRAL. Thank you.
Thank you, Anna. So briefly for give you an idea of what we have done on MSMEs at UNCITRAL, and also connecting with the legislative guide on insolvency law, part 5. Is at UNCITRAL, we work on these legislative instruments, trying to understand the main characteristics of MSMEs around the world. And they are family owned and run, and the employees are usually family members. And they rely on friends and family for the finance, and they face disproportionate impact of regulations, and they mainly operate in the local market. And MSMEs are vulnerable, but they were even more vulnerable during the crisis because they were usually operated in the informal market. So they were invisible, and the way that they were not registered and not benefit from all the programs of governments, such as subsidies or tax exemptions or any other programs. In the next slide, we are presenting all our text on insolvency, part of them. The others are available on our website online. And all these framework on insolvency, when it applies to all enterprises, but on MSMEs, the idea is thinking small. That's being taken into account the reality of small and micro entrepreneurs when they are facing an insolvency, and during the crisis, they were very vulnerable, and they were family behind, and they probably didn't know that they could have a legal system that they could support them in this panic zone when they have a lot of debts and creditors behind them. So what is the legislative guide on insolvency law, part 5, offer them the possibility of a start insolvency proceeding as pre-insolvents when they are in this phase that they know they are going there, but they are not there yet. So they have all this system that they can force creditors to sit in the table and negotiate with them. Obviously, if the entrepreneur is insolvent, then the court will open the insolvency proceedings. And for all of that also, because all the debts that they have personal debts and they have business debt, and these systems allows them to treat them in a comprehensive way. And also is because it's the support of the authorities to educate them on financial and accountant, because there are a lack of informations, and with informations they could take better decisions for their business, and decided the system will help them to liquidate or not viable enterprises and rescue all the viable enterprises. And the legislative guide the model laws allows the state to harmonize the national legal system on insolvency regime. As you know, we could say that there is a misconception that the model law only works for large enterprises, because during the pandemic, we have seen this morning this trend toward digitalization, and there are small enterprises that they are growing with digital assets, and the model law will help them to face these insolvency proceedings in the way that rescue debts or creditors in different jurisdictions, protect them with an insolvency regime that is harmonized. In the next slide, this is a topic that was covered this morning, the arbitration. We have a robust regime on arbitration with conventions that give certainty for all that they have an arbitral award, and they would like to recognize and enforce these foreign arbitral awards, and as well model law international commercial arbitration, and arbitration rules that are ready to be used by private parties to insert into the contracts. And then the expedited arbitration rules, I invite all of you to check. They have also model clauses ready to be used by private parties. And also the expedited arbitration rules. You have a note explaining the main articles, and these expedited arbitration rules expressly allow for the use of technology in arbitration, as we have seen this morning is so important for remote hearings, and also organizing a case management conference online that will save cost and time for all the disputing parties. In the next slide, we would like to show you one of the elements as well of the alternative dispute resolution is mediation. This is a special regime that we have, a complete regime, sorry, with a convention, model laws, mediation rules, and notes on mediation. And for the definition of mediation as is a consensual, informal, and flexible process. It's quicker than litigation, and during COVID, we have seen on all the stock-taking exercise that we have been doing, that mediations give parties the chance to understand each other point of view, and then together working toward a solution that work the best for them. And it's time saver and imply less cost than in an arbitration. And you have seen here that we have a complete framework on mediation. The next slide is what we have talking about this morning. Some of the representatives of the international organizations, mostly those that they are working in the international transport of goods by sea, or and is the sale and transport of goods. We have the Convention on Contract for the international sale of goods. As you've seen during the pandemic, as the representative from UNCTAD was saying, all the transports were in long distance, and also an increase in the shipping. But during the pandemic, all the shippings were not arriving in due time. That's increased all this disruption in the supply chain. So, and also we witnessed a problem with the transmissions of paper-based transport documents. What we have at UNCITRAL is legal text, just as a convention for the contract of the international sale of goods. That means that when parties of the contract are placed in different business places in contracting parties, and when the law also apply when the law of the contracting state of this convention is the law applicable in the contract. And thanks to this convention, suppliers were able to excuse themselves with the force majeure clause. He's very enthusiastic for this convention.
Somebody disagrees with you, Marianela.
Yes. So that allows this an article of this convention when included in the contract. If you have a contract and the contract is one of the parties is the place of business is in one of the contracting states, or you have chosen in the contract the law of one of the contracting states, you have access to this force majeure clause that is able to excuse one party for a failure to perform any of its obligation, with a certain condition is the failure is due to an impediment beyond its control. That was the case during COVID. That could not reasonably expected that is going to happen at the time of the conclusion of the contract, or it could be avoided or overcome for its consequences. So since like COVID comply with all the requirements of these articles, and also there is an article on anticipatory breach that is included in this convention. As you can see, post-COVID time also is important to have in mind all these articles or legal regime, because it's every time more important to have a contract with the right clauses in order to excuse yourself in cases such as the COVID. And also we have the Rotterdam Rule, is a multilateral convention on contracts for the international carriage of goods, wholly or partly by sea. This is a convention that is very important regarding the transport of documents, because this convention adopts a medium-neutral approach, enable the use and effect of electronic transport records, or the replacement. It works together with the famous lady Melita, even if it's has not entered into force. It's possible to issue and use electronic commercial documents, and we are talking here about the bills of lading and the existing legal regime of this convention. And with that, I have concluded the part of the presentation of the main elements of the toolkit.
Thank you very much. And so I will end with the sales pitch. So why should states enact and become parties to UNCITRAL texts? And by no means don't take that as the only means and the only ways, but allow us a little bit of publicity. So first, and that is what you will find in the toolkit, what happens in situations of trade disruptions and how can states reduce, or by how can they contribute to reducing trade disruptions? Well, as we've heard this morning, by states and by international organizations, one of the elements that has really shown all its importance and that has saved many countries from a lot of difficulties is the digitization of the trade operations and processes. And in order to do that, I repeat what I said earlier, it's important to have the infrastructure, the legal infrastructure in place to be able to resort to e-commerce, to e-signature, to use the e-signature. And one of our forthcoming important missions is going to have e-signatures authorized and allowed on arbitral awards. The Electronic Communications Convention, the Model Law on Electronic Transferable Records, and the most recent Model Law on Identity Management and Trust Services. With this range of texts, you will have the infrastructure that is needed to build your digital economy and to allow this electronic commerce that has shown so much of its importance during the COVID period. Let's move to the next slide, which shows, again, while trying to reduce trade disruptions, the supply chain disruptions that can be dealt with through the CISG and the Rotterdam rules, insofar as they set up default rules when a particular situation kicks in, like the one of COVID, which requires special arrangements to ensure that for example, either the payment or the performance of the contractual obligation can be delayed for some time. Also a robust credit and insolvency system to be in place. We've looked at insolvency. A number of states have enacted legislation, taken measures in the area of insolvency, and particularly for MSMEs. A strong model law on secure transaction based system to allow MSMEs to access credit, and legislative guide on insolvency for MSMEs that helps addressing measures specifically to the smaller ones. As Marianela said in her presentation, you have to think small in order to give adequate response to these very, very small businesses. Second challenge is the resolution of trade disputes due to trade disruptions. And here we have an entire framework starting with the arbitration convention, model law, and rules, but we have the same thing also for mediation, where we have a very complete framework now, ranging from the Singapore Convention, the model law, the rules, and a number of supporting texts. And last but not least, the notes by the Secretariat to facilitate ODR proceedings in developing countries and using ODR systems. So this is really for dispute resolution, again, sort of a basic infrastructure that allows, once you have it in place, to pick and choose what could be the most adequate dispute resolution mechanism, and to respond to these disruptions that were created by the pandemic. Now, let's look into the future. And for this, I'm going to look at future trade and UNCITRAL instruments and how they help states and contracting parties in future global emergencies. For states, it's obviously legislative and non-legislative text that UNCITRAL provides, and that states can then either adopt and then include into existing text or into future text, or also consider model laws, technical notes, guidance notes, and other resources that are available to help states in their legislative actions. And for the contracting parties, which is the next slide, there are rules and technical notes that are available for parties involved in contractual disputes, but also in drafting contracts and in as default rules in contracts, CISG, but also rules that can be UNCITRAL rules on mediation or on arbitration that can be included, and technical notes. So that is very much what we wanted to say. I'm sorry that we had to rush you through our pitch exercise, but I think that it's a pretty comprehensive panorama of what UNCITRAL texts have available. Of course, it's only a very limited part of the major issues that the crisis has generated. It is the trade response, is the response to trade disruptions, but we still think that, as Salim Moulan was saying in the early and his introductory presentation, a lot of it is already there. There's no need to reinvent the wheel. It's just a matter of using the tools that are there and in making states realize that these tools work together and fit together in a toolkit. Thank you very much for your attention.
Thanks a lot. Thanks indeed. This was very, very useful and very interesting and deep presentation about the all available toolkits that UNCITRAL has to offer regarding the areas that it covers, and it's quite wide. And I think it covers all of the areas of the governance in the stated, and think will be very useful to maybe somehow remind about this available toolkits to our partner or agencies inside the government. I think we should do that when summing up the conference and creating some concluding observations. And I know from my experience that there are in many areas inside our country, we are moving in these directions that we have, like you have identified in your presentation, for example. I know that the Ministry of Finance is heavily engaged with the reform of the procurement system, and they are now very heavily doing that, the e-procurement system, and I'm sure that they are looking at the model law, and also they want to create some unified system of that, and also including the PPP framework too. I'm sure that that's an important area as well, and which has been an important aspect relating to also protection of the investors, also the interests of the investors. That's very important to have this regulatory framework in place in a country. And of course, moving to the degree of the enactment of this toolkit and the different instruments by different member states, of course, that depends on many variables and many aspects, that depending on the degree of development of the country, like and where the country stands in terms of economy and the size and many aspects of geographical area. But still, and I know that we cannot ideally have this complete or like ideal, near ideal unification between the countries, but that's the aim that maybe we should strive for. And of course, the big area, which is I think the rapidly developing field, that's the AI and the use of the AI and the machine learning or machine contracting, as you say. That's quite a fascinating area where I think we have to catch up. That's my understanding. And Can we open the chat?
Oh,
The messages. Yeah, I see some messages there.
Actually, setting the it's perfect.
Sorry, can you repeat your question? Because we have some technical problems.
Jim, we cannot hear you very well. Can you take the floor again to put your question, please?
No.
No questions? Okay, yeah, I think we have quite went I think rather quick through a very dense area of a lot of information. That's why maybe. Okay, sure.
So let me just say that this is not your last chance of speaking up on the toolkit. It will be presented at the commission session. And we are going to discuss the toolkit itself on the 17th and the 18th of July. So this is the week where we're discussing the progress made by the different working groups, but also the development of the projects that are not yet or that are not at all with working groups. And in this case, it will be discussed on the 17th and 18th of July. So we will present the toolkit and we hope to have a discussion by the Commission in addition to a guidance on what next.
Yes, from Army and Permanent Mission, please. And Mr. Ambassador, please.
Mr. Ambassador, we can't hear you. You have to unmute yourself.
We can't hear you. We have to improve technology.
Can you hear me now?
Yes, perfect.
Is it okay now?
It's very good. Thank you.
No, I can't. I don't hear you. Well, I suppose you hear me, so I will go ahead, though I don't hear you. Well, I don't have any actually specific question, but rather a comment. First, I would like to thank Anna Juban-Brett and her team at UNCITRAL as the co-organizers of this event for the valuable efforts and cooperation. Also, I would like to greet my good colleague and friend, Yerisha Gyrakosyan, and thank him for leading and helping us to moderate this two session. I also would like to express our appreciation to all the panelists for their insightful presentations, to give us an opportunity to learn about the experience of other states aimed at strengthening the resilience of the trade infrastructure. And also we have learned about various aspects of the challenges posed by such a global health crisis by representatives of different international organizations. I really thank you for that. As you have already mentioned, Armenia was one of the countries that co-sponsored this initiative related to the need to research the impact of COVID-19. And I think we are in a way honored and pleased to see that the first time the toolkit has been presented in Armenia. So we work hard to make it possible. And again, thanks all who made this event possible. Thank you for that.
Thank you, Ambassador. Yeah, I think I think now we can turn to closing then. Shall we start? Please, and give me the floor.
Well, thank you very much. Thank you, Mr. Ambassador. And it was a real pleasure at our end as well to co-organize it with the help of your colleagues in Vienna, but also the colleagues in the Ministry of Foreign Affairs. We heard so much and we had so much food for thought that I hope that we will have the opportunity to let it sink in a little bit and to come to the Commission session with some comments and some recommendations on how to further promote this toolkit and how to enrich it, maybe with other experiences that maybe not reflected as they are currently, and also maybe continue to advertise UNCITRAL's work through this toolkit, which is very clearly focused on COVID-19, but also goes way beyond into the challenges of today's economy in all regions. So again, thank you very much for this opportunity. Thank you for having us here in Yerevan. It's been a delight, and it's the delight has not ended yet because there is still dinner to come. So we're very much looking forward to seeing all of you at the Commission session. And in the meantime, don't hesitate to write to us if you have any specific comments on the toolkit before the Commission and before its discussion on 17th and 18th of July. Thank you.
Thank you very much. Just 2 words from my side. I think it was a very useful exercise to conduct, and although it was very the period of time was very short, to cover too many very important and very deep topics, which each of which has very deep and very comprehensive content. But I think we managed to go through all of the areas, and I think this exercise is very useful for the government representatives specifically, because the government representatives most of the time need this quick nutshell presentations of the available toolkit and also of what's happening inside UNCITRAL working groups and what instruments are available, and those can well be serving a very good guides and very good resources for the governments to start conducting the reforms in that direction. And I'm sure that that will be taken very good notes by the Armenian colleagues. In any case, we as well be very much engaged in one of the working groups of UNCITRAL, but still will be also helping our colleagues at the MFA to spread the word around our agencies, relevant agencies. We have the Ministry of Finance, relevant agency for the procurement system, establishment Ministry of Justice, relevant for the e-legislation or legislation relating to paper and document circulation and signature, Ministry of Economy, which is responsible for the trade part of this whole story. And of course, any other agency that is relevant here, because I think that's the most use that we can make of this event. But still, again, thanks to the Ministry of Foreign Affairs for organizing this. Thanks to UNCITRAL for the efforts and organization. And thank you all the participants who made it through the end and who still remain connected through Zoom call. So thank you for your patience and interest in this very interesting and very complicated topics. Thank you.
Thank you.